5 seconds to go. Start. In the aforesaid context, we may remind the trial courts and the high courts of what came to be observed by this court in Gudi Kanti Narasimhulu versus Public Prosecutor High Court reported in 1978 1 SCC 240. We quote, "What is often forgotten and therefore warrants reminder is the object to keep a person in judicial custody pending trial or disposal of an appeal." Lord Russell, Chief Justice, said, "I observe that in this case bail was refused for the prisoner. It cannot be too strongly impressed on the magistracy of the country that bail is not to be withheld as a punishment, but that the requirements as to bail are merely to secure the attendance of the prisoner at trial." The court further observed that over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that bail is not to be withheld as a punishment. From our experience, we can say that it appears that the trial courts and the high courts attempt to play safe in matters of grant of bail. The principle that bail is a rule and refusal is an exception is at times followed in breach. On account of non grant of bail, even in straightforward open and shut cases, this court is flooded with huge number of bail petitions, thereby adding to the huge pendency. It is high time that the trial courts and the high courts should recognize the principle that bail is rule and jail is exception. In the present case, in the ED matter as well as the CBI matter, 439 witnesses have been named. The case involves thousands of pages of documents and over a lakh pages of digitized documents. It is thus clear that there is not even the remotest possibility of the trial being concluded in the near future. In our view, keeping the appellant behind the bars for an unlimited period of time in the hope of speedy completion of trial would deprive his fundamental right to liberty under Article 21 of the Constitution. As observed time and again, the prolonged incarceration before being pronounced guilty of an offence should not be permitted to become punishment without trial. As observed by this court in the case of Gudi Kanti Narasimhulu Supra, the objective to keep a person in judicial custody pending trial or disposal of an appeal is to secure the attendance of the prisoner at trial. In the present case, the appellant is having deep roots in the society. There is no possibility of him fleeing away from the country and not being available for facing the trial. In any case, conditions can be imposed to address the concern of the state. Insofar as the apprehension given by the learned ASG regarding the possibility of tempering the evidence is concerned, it is to be noted that the case largely depends on documentary evidence which is already seized by the prosecution. As such, there is no possibility of tampering with the evidence. Insofar as the concern with regard to influencing the witnesses is concerned, the said concern can be addressed by imposing stringent conditions upon the appellant. Stop.